Good afternoon, everyone, and welcome to the third edition of our interview series. We are talking again today about institutional perspective to arbitration, and today we are very pleased to have a representative of the Asian International Arbitration Centre in Kuala Lumpur. But before we represent our speaker, our interviewee today, I would like to briefly introduce myself and my core interviewer, Dmitry Marenkov. My name is Olga Hamama. I'm co-founding partner of V29 Legal. Dmitry Marenkov is a fellow of the Chartered Institute of Arbitrators. We are both acting as arbitrators, among others, and have initiated in 2017 a conference on CIS-related disputes in Germany, Frankfurt. The third edition of the conference was supposed to take place next year, but because of COVID, this is not going to happen, and that's why we offer you to keep the dialogue going this interview series under the name of the platform, which is MOST. So now to you, Dmitry, so you can introduce our esteemed guest today.
Thank you, Olga, for the kind introduction. It is my pleasure to introduce to you our today's guest, Tatiana Polevshchikova, who is currently serving as Deputy Head of Legal Services at the Asian International Arbitration Centre in Kuala Lumpur, Malaysia. Tatiana has been with the AIAC since 2016, first as an intern, then as an international case counsel, and currently as Deputy Head of Legal Services. Tatiana graduated from Mary State University in Russia and holds an LLM degree in dispute resolution from the Washington University in St. Louis School of Law, Missouri, United States. Tatiana attended the LLM program as a Fulbright scholar. Tatiana previously worked as an in-house lawyer in Russia and also as an attorney with a law firm in Moscow and Amsterdam. It is our pleasure to pose some questions to you today about arbitration in Asia and the Asian International Arbitration Centre in particular. Welcome, Tatiana.
Thank you so much, Dmitry and Olga. It's a great pleasure to share this session with you today. And congratulations on this absolutely great initiative. It feels I feel absolutely privileged and great to feel connected, although being so far away.
Thank you very much, Tatiana. Thank you for accepting our invitation. And maybe before we go into the details and arbitration-related details, I think one question which would be interesting for our audience as well is to hear from you, how did you make the transition from Russia to Kuala Lumpur, well, Asia in general and Kuala Lumpur? Could you share some insights with us how your journey looked like?
Sure. Thank you, Olga. I started as a Vis Mootee in 2011 when my law school decided to participate in the William C. Vis International Commercial Arbitration Moot in Hong Kong. And I believe we were the very first Russian team going to the Asian rounds in Hong Kong. And I always was interested in Asia. It was always on the back of my mind. I think this passion to Asia comes from my granddad, who was very interested in the history of the ASEAN countries, but unfortunately, he was not able to travel to Asia and discover this part of the world. So I'm happy that I am realizing my granddad's dream, I guess. Speaking of the transition, I mean, I started, as I mentioned, as a Mootee, and then when I started developing my professional career as a lawyer, and subsequently as an arbitration lawyer, everyone was talking about development and increasing attractiveness of the Asian seats, especially among the Russian-speaking part of the market. And once when I was at the conference, it was AAA Exit conference in New York back in 2014, I was having this coffee break with different arbitrators, and some of them, they were from Asia, from Hong Kong and Singapore. And they were just recommending me to try, applying to different jurisdictions in Asia. And that's what I've done. I started as an intern in Hong Kong, and then I received a job offer from Kuala Lumpur. That's how I settled down here in Malaysia.
And what is life as a foreign arbitration practitioner like in Malaysia? Have you had any memorable moments over the past 5 years?
A lot of memorable moments. It's been a bumpy road, to be honest. A lot of things were happening here, but at the same time, I also feel privileged that I witnessed and participated in so many developments here. A lot of projects have been started here in the last few years, international competitions, ADR week here, and I mean, many other things, amendments to the Arbitration Act, revision of the AIAC Arbitration Rules. The team of the center expanded significantly. It's a very diverse legal team nowadays, so it's very interesting to work among lawyers coming from different legal backgrounds, different cultures. It's very enriching.
Very interesting. And so coming to the Asian International Arbitration Centre, AIAC in Kuala Lumpur, could you share some light with us on your specific responsibilities within the organization?
Sure. So my main responsibility with the AIAC is the supervisory work. I supervise case management and arbitration. All arbitration matters we manage, we administer as a center. Under the AIAC Arbitration Rules 2018, 2017, 2013, as well as under the AIAC Fast Track Arbitration Rules. I also assist the director with the appointment of arbitrators under the Arbitration Act of Malaysia 2005, because the director of the center acts as the default appointing authority in ad hoc matters seated in Malaysia. We also assist from time to time in ad hoc matters as a center. For instance, we assist with the fund holding arrangements. Starting from 2019, we also started appointing tribunal secretaries here in Malaysia. So that's the main part of my work. On top of that, I'm also involved in international cooperation, whether it's cross-institutional cooperation or sometimes just different collaborations with not only institutions, but foreign law firms or foreign arbitration or ADR practitioners, UNCITRAL, and so on. And of course, part of my work is also what I'm doing on a weekly basis is policy work. It's quite interesting as well, because when you work for an arbitral institution, you also participate in the development of certain institutional documents, whether it's, for instance, we are currently working on the protocol, on the AIAC protocol for the administration of arbitration under the UNCITRAL arbitration rules. It's a very new instrument we are planning to use, and I'm happy to be part of this.
And could you please tell us a little bit more about the history of the Asian International Arbitration Centre? When was it founded, and it was renamed at a certain point in time? What were the reasons for that?
Certainly. So the Asian International Arbitration Centre was established under the umbrella of the Asian and African Legal Consultative Organization. This is the very first center established under that umbrella. And it acts on the basis, it exists on the basis of the international agreement. It's called the Host Country Agreement. The Host Country Agreement between the government of Malaysia and ALCO, the Asian and African Legal Consultative Organization. As I mentioned, it was established back in 1978. And by the 40th anniversary of the center, which was in 2018, the center itself was already established not only as a dispute resolution center, which is able to address the needs of the Malaysian users, but also proved its reputation as an international ADR hub by that time already. And that's why the decision was made to change the name of the center in order to reflect the work we are doing, so that it's not only Malaysia-centric, but Asia-centric.
Thank you, Tatiana. So looking, like having, in preparation for this interview, I've noticed that there was a number of developments in the recent years, and also the number of cases seem to be continually on the rise. So could you take us through the recent developments or most important developments from, in your view, in the last two to 3 years of the center?
Certainly. I mean, looking back in 2017, 2018, we introduced certain amendments to the AIAC Arbitration Rules. The most important ones were the introduction of emergency arbitrators. And I was happy to witness the appointment of the very first emergency arbitrator in 2019 under the AIAC Arbitration Rules 2018. On top of that, we also introduced new provisions on joinder and consolidation. The other important change was introduction of the technical review of draft final arbitral awards as well. So that these are the main provisions basically that have been amended back in 2017 and 2018. And at the moment, we are also working on the new edition of the AIAC Arbitration Rules. Hopefully it will be released and available for the comments next year.
Tatiana, you mentioned that the AIAC was founded on the basis of the Asian African Legal Consultative Organization. Does it mean that there is a certain number of Africa-related cases there at your center?
Unfortunately, we don't have any Africa-related disputes yet. I'm not sure if it was the goal at the very beginning, because there are 4 other arbitral institutions established under the same umbrella, under the ALCO umbrella. One of the institutions which actually deals with African disputes is the Cairo International Arbitration Centre.
And you also mentioned the technical review, which is undertaken by the director. It's Rule 12 of the AIAC Arbitration Rules. What exactly is the scope of the review done by the director of the institute? Is it what is often referred to as scrutiny, or is it something else?
It's different from scrutiny. It's a very limited review. It's basically limited to the computational errors, any obvious errors we can find in the draft, such as, for instance, if we see that the tribunal overlooked the seat of arbitration, or wrongly calculated the cost of the proceedings, or omitted the date of closing of arbitral proceedings, these kind of things.
And how many people read a draft award at the AIAC?
It's usually multiple people within the legal department, and then it goes to the director, who subsequently reviews the award as well and approves the comments subsequently being communicated to the arbitral tribunal. It's possible to have multiple rounds of review. The most interesting matter we had earlier this year, we had 5 rounds of review of the same final award. It was very time consuming, but very, very interesting for all of us.
And how much time does it usually take?
We usually take not more than 2 weeks for the first round of review, and we give the 10 calendar days to the arbitral tribunal to review our comments and get back to and revert to us. If there is a need for the second round of review, it's usually less than 10 days, usually 5 to 6 calendar days. So overall, it doesn't take more than 3 to 4 weeks.
And are there any common shortcomings, errors which you see most often as a kind of an advice for arbitrators what not to do?
It's hard to still, come up with the most common errors, because the technical review itself was introduced only in 2018. But I would say the most common mistake in the awards I was reviewing was the computational errors. It's quite often that the tribunal overlooks or omits certain elements of the costs of arbitration. So, and it's quite easy for us to identify this problem, because as an arbitral institution, we keep track of all the costs from day one, from the date of the commencement until the very end. So I think it's the most common mistake as of today.
And talking about the AIAC arbitration rules in general, Are there any distinct features, any particularities arbitration practitioners should be aware of when agreeing to AIAC arbitration agreement or conducting arbitral proceeding under your rules?
Definitely. First of all, being an arbitration practitioner who's never had any experience with arbitration conducted under the AIAC Arbitration Rules, you need to pay attention to the structure of the rules. So there are two parts of the rules. Part 2 is called UNCITRAL Arbitration Rules. So it's a verbatim adoption of the UNCITRAL Arbitration Rules 2013. And Part 1 is named the AIAC Arbitration Rules. So there's some modifications to the UNCITRAL Arbitration Rules. And if there are any discrepancies between Part 1 and Part 2, Part 1 will prevail. That's the first most important thing you need to keep in mind. Also, you need to pay attention to the appointment procedure under the AIAC Arbitration Rules. In particular, if you look at Rule 4.7, you will notice that all appointments of arbitrators under the AIAC Arbitration Rules are treated as nominations. So even if, let's say we have a 3-member tribunal, claimant nominated its arbitrator or appointed its arbitrator, respondent appointed its arbitrator, these appointments are not final. In order to finalize these appointments under the AIAC Arbitration Rules, you have to ask the director of the AIAC to confirm arbitrators. Once these 2 arbitrators are confirmed, they can also nominate the presiding arbitrator, who subsequently also has to be confirmed by the director of the AIAC.
Tatiana, just a brief follow-up question here. So does it mean that there are cases that the director would not confirm such an appointment? And if so, you know, which are examples? Do you have any examples of cases where this would be the case?
In my experience, we had only one matter where, you know, the issue of confirmation was raised as such, and in that particular case, it was due to the potential conflict of interest.
Okay, and maybe also in this context, it is interesting to address the arbitrators list as well, because as far as we understand, AIAC has a list of arbitrators. Could you tell us more about this list? Is it a mere suggestion, or is it a closed list of arbitrators?
Sure. So first of all, if you have a matter under the AIAC Arbitration Rules, all you need to know is that your choice of arbitrators is not limited with the list. Although, if you need any assistance with the selection of arbitrators, you can always rely on the AIAC panel of arbitrators. Also, if the parties request the director of the AIAC to appoint one of the arbitrators or all members of the tribunal, the director usually relies on the AIAC panel of arbitrators. But again, as I mentioned, it's not mandatory for the parties to, you know, to limit their choice with only those who are impaneled by the AIAC. It's quite interesting to see the development of the list itself, because if we look back in 2010, the list was quite limited, and it had mostly domestic practitioners, mostly Malaysian practitioners. As of today, we have more than 2,000 practitioners or arbitration professionals from all over the world impaneled by us. And it's quite a diverse pool of arbitrators. So yeah, I guess it's a very interesting development.
And sorry, since you addressed also this the topic of diversity, could you tell us whether AIAC signed the Equal Representation in Arbitration Pledge? And if so, do you see already direct effects of the commitment to the pledge?
Yes, we signed the pledge, and I was very, very happy and privileged to actually witness this moment in 2019. It was advocated by the many members of the local arbitration community, and the center signed the pledge. Speaking of the impact of the pledge, I mean, even before the pledge was signed, we were already paying attention to taking into account the diversity of arbitrators or adjudicators we appoint. But I mean, knowing that the center signed the pledge, there is even more encouragement for us to work on even more projects focused on the diversity in arbitration or adjudication, mediation. As an example, earlier this year, we were planning to have the Diversity Day, a day before the ADR week here in Kuala Lumpur, but because of COVID, everything was cancelled. Regardless of this, we still decided to commit to diversity, and instead of having one day, one diversity day, we organized multiple webinars on diversity in arbitration. It basically was the entire week. So we had 4 different webinars. The first one was about gender diversity. Second one was about age diversity. The third one was about professional diversity for non-lawyers in arbitration. And the fourth and the last one was about racial and ethnic diversity in arbitration.
And talking about arbitrators' appointments, how are usually default appointments dealt with? If one of the parties, for instance, respondent does not appoint an arbitrator, what happens then? What's the role of the secretariat?
Then the claimant can ask the director of the AIAC to appoint under the AIAC Arbitration Rules, Rule 4. And then the director will appoint the arbitrator, whether it's the first or the second arbitrator, on behalf of the party which failed to appoint its own arbitrator.
And are those default appointments limited to the list?
I don't think they're limited, but usually we rely on the list of arbitrators we impanel.
So coming back maybe to the subject matter also of arbitration proceedings, are there any disputes which are managed by the center, administered by the center in general? Could you tell us whether there are any specifics with regards to nationalities of the parties, also nationalities of arbitrators, or even subject matters of the disputes? Are there any tendencies when it comes to these topics and the institution itself?
Yes, absolutely. In terms of subject matter of disputes, Malaysia is not an exception, and similar to other jurisdictions in the Asia Pacific, most of the disputes we administer, they're construction disputes. However, if we look again at the, for instance, 2018 report of the AIAC, the annual report, we will also see that we have maritime matters, oil and gas disputes, shares disputes. So I think because arbitration itself develops, the interest to arbitration is growing. More and more parties, not only to construction disputes, but to any other areas, to any other disputes, they do consider arbitration more and more often as a way of resolution of their disputes. But still, yeah, as I mentioned, most of the disputes we administer as of today, they're construction matters, and most of them, they're domestic matters. However, the number of international disputes is also growing slowly, but it's growing. Again, if we refer to 2018 report of the AIAC, we will notice that we registered disputes with new nationalities such as the United States, Korea, India, some other countries. And when we publish the 2019 report, hopefully early next year, early 2021, you will see that we also registered quite a few new interesting nationalities last year.
And talking about international cases which are administered at your center, is there any common choice of substantive law which you see? Is it mostly Malaysian law or something else?
Yeah, just continuing on the last question, because most of the disputes, they're still domestic disputes. The most popular law which applies to the contract is still the Malaysian law. Although yes, we do see foreign law being applicable to in international disputes, but it's still just not the trend as such.
And as a reaction to the length of the arbitral proceedings, a number of arbitration centers worldwide have introduced expedited rules, so fast track arbitration procedure. Does the AIAC have something like that?
Yes, so the AIAC has its own set of fast track arbitration rules. We have two different sets of fast track arbitration rules, fast track arbitration rules 2017 and 18 at the moment. And it's quite interesting because usually the expedited procedures, they form part of the main set of arbitration, of institutional arbitration rules. And here at the AIAC, it's a separate set of arbitration rules. There are two different types of proceedings under the fast track arbitration rules. It's document-based, documents only, and the second type where you know, as always, you will have a hearing, similar to the to arbitration and 2018 arbitration rules, for instance. The timeline is quite efficient. So it usually takes up to 180 days to resolve a simple matter under the AIAC fast track arbitration rules. It's also cheaper compared to you know, resolving disputes under the AIAC 2018 arbitration rules. They don't fit, you know, a broad category of disputes, but we see that more and more parties, especially in small matters, they do adopt AIAC fast track arbitration rules. Back in 2019, we had 5 very interesting matters where the parties decided to adopt a waterfall dispute resolution clause, where they referred their disputes, multiple disputes, to mediation under the AIAC mediation rules first. They managed to settle some of these disputes in the course of mediation, and those disputes which haven't been settled under the mediation rules, they referred to arbitration under the AIAC fast track arbitration rules. And those 5 matters, they were quite interesting because all disputes were resolved within 6 to 7 months.
And do I understand it correctly that those fast track rules are is an opt-in scenario, so it doesn't depend on the amount in dispute?
Yes, it doesn't depend on the amount in dispute. However, there is a provision which basically says that if the amount in dispute is lower than the default number in the rules, then it will be document-based proceeding.
And what's that amount?
If I'm not mistaken, in US dollars, it's 75,000 US dollars.
Oh, okay. Rather low, yeah.
Tatiana, since you mentioned mediation proceedings as well, at least I think it's seems to be one of the tendencies which might be also COVID related, at least in Western Europe, that we see more and more mediation proceedings coming up, or even like arbitration proceedings resorting when the parties are resorting to mediation, although arbitration has already been initiated. Is it a development that you also see in Asia and in your center?
Absolutely. The interest in mediation is also growing. We receive more and more inquiries about mediation every year. Parties are more familiar with mediation, much more familiar with mediation nowadays compared to 4 years ago, for instance. And we also have a Malaysian Mediation Center here in Malaysia. They're also doing a great job in terms of promotion of mediation among Malaysian users. Speaking of mediation, we are also working on a cross-institutional project, which is quite interesting. We partnered with the Hainan International Arbitration Court, and we decided to cross-impanel Malaysian arbitrators and mediators. The scheme works in a way that we recommend certain Malaysian arbitrators and mediators to be impaneled in Hainan, and Hainan International Arbitration Centre recommends its professionals to us. And it applies both to arbitration and mediation.
Tatiana, you mentioned at the beginning that AIAC has employees, the secretariat from different cultures, different nations. Could you please specify from which jurisdictions do you have lawyers at your center, and maybe how many people work at the AIAC?
Sure. When I joined the AIAC, we had only a few nationalities. If I'm not mistaken, only 3 nationalities. We had a consul from India, a consul from Spain, and Mexico. So then I joined, I think I was the first one consul from Russia to join the center. At the moment, we also have a consul from Australia, 2 consul from Indonesia, 1 consul from India, and 1 consul from the United States.
Yeah, interesting. I mean, is there any specific reason behind it? You say that the number of foreign parties to arbitration is on the rise. At the same time, there seems to be a very constant number of foreign trained lawyers working for the center. So is it just, you know, because it happened this way, or is there a specific reason or logic behind this?
It's not only case management reasons, not only for case management reasons, but also for depends on the projects we develop as an institution. For instance, we are quite actively planning our development in at the Indonesian market. So we have 2 consul from Indonesia covering that part. We have 1 consul from India who is very actively marketing AIAC in India. We have a consul from the US who develops a new project on tech disputes. And yeah, I mean, it depends on the projects, of course, experience, their qualifications, and interest in bridging their own countries with the Asian markets. Oh.
Interesting. And connected to this topic, so you know, one has an impression that the arbitration community seems to be, well, growing and to be quite large in Malaysia. Is it true? Also, I think you've managed that you've been one of the co-initiators, or at least like co-chairs at the moment, of the young practitioners group in Malaysia. Is it so? So does it mean that there is a growing demand and growing interest in this dispute resolution method in Malaysia in general?
Yes, absolutely. The interest is growing, the industry is growing, and therefore the ADR community itself is also growing. Many more young practitioners, they're interested in focusing on arbitration, if possible, from the very first day of their careers. So once they, pass the bar exams and they, join the local bar, it's quite often nowadays that they also have at least some experience, at least a flavor of arbitration nowadays. But yeah, I mean, speaking of the young practitioners group, yes, it's a very well-developed platform nowadays. When we started, if I'm not mistaken, we had only 1 group here in Malaysia, which is the CIR Young Members Group. As of today, our Young Practitioners Group, we have almost 2,000 members from more than 40 countries from all over the world. One of the major projects we're planning to realize in 2021, next year, is to start appointing regional representatives from different countries, so that we'll be able to partner with more countries. And again, for diversity reasons, it will also give more opportunities to younger lawyers and students and fresh graduates to learn about ADR, not only in Malaysia, but in the Asia Pacific region, to share their experiences and maybe help each other to grow, to establish new connections, to exchange information about professional opportunities existing in the Asia Pacific and any other parts of the world.
Tatiana, you mentioned that a large part of the AIAC's caseload at the moment is domestic. I wonder what the most common language of arbitration is in the proceedings at your center.
Definitely English. English is number one. We had a few matters where Bahasa Malay was the language of arbitration, but still it's more of an exception. Usually in most of the proceedings, it's English.
And talking about the caseload altogether, how many cases does your center have annually or at the moment?
We haven't released our statistics, 2019 statistics yet. If we look back at 2018 report, we registered 915 cases overall. That includes arbitration, adjudication, mediation, and domain name dispute resolution. So if we speak about adjudication, which is statutory procedure here in Malaysia, it's aimed at the resolution of the payment claims in the construction industry. It's almost 800 new matters registered in 2018. And if I'm not mistaken, 108 arbitration matters, and the remaining part, which is 22 or 23 matters, it's mediation and domain name disputes. So arbitration is still growing here in Malaysia, as I mentioned, both domestic and international. But if we look at 2019 numbers, again, we haven't published it yet, but we already announced the arbitration numbers end of last year. The number of new arbitration matters registered by the center in 2019 doubled. So by the end of December 2019, we registered almost 160 new arbitration matters. That includes administered arbitration matters under the AIAC Arbitration Rules 2018, as well as matters under the Untitled Arbitration Rules and appointments in ad hoc arbitration matters, which are seated in Malaysia.
Interesting. And well, since we are touching on these developments and also topics of foreign parties which participate in arbitration proceedings, so our platform, like most platform, is mostly looking on the CIS angle of disputes. So can you share with us your insights with regards to CIS-related developments or disputes? Do you see any, or do you think there is a potential for such disputes in the future?
I think the potential is huge because the interest to the Asia-Pacific region is growing as such. I remember about 2 or 3 years ago, I attended the One Belt, One Road Summit in Hong Kong. And at that point of time, we had about 3,000 participants. Many of them, they were coming from the CIS jurisdictions, Kazakhstan, Uzbekistan, Mongolia, and so on. And more and more lawyers, they inquire information about Asian jurisdictions, be it as a seat of arbitration or available dispute resolution mechanism, arbitration, mediation. We haven't registered any CIS-related disputes yet. But I think, taking into account all current developments and increasing cooperation between these two markets, the CIS jurisdictions and the jurisdictions of the Asian Pacific, in the Asia Pacific, it's very likely that it's not only the interest that will be growing, but also disputes, and therefore they will be considering Asia Pacific jurisdictions and institutions for the resolution of their disputes.
Talking about CIS-related disputes, have there been any examples of maybe CIS awards being enforced in Malaysia, or vice versa?
From the top of my head, I have this, I remember this dispute. It was an AIAC arbitration, the Russian AIAC, open type joint stock company Efirne. So it was a matter between a Russian company and a Malaysian company, and the final award was issued against the Malaysian company. Therefore, the winning party, the Russian company, decided to enforce the final award in Malaysia, and it was successful. So the award of the issued under the rules of the Russian AIAC was enforced in Malaysia in 2011. It's hard to say about other CIS jurisdictions. I haven't made any research yet, but speaking of my home country, Russia, yes, I think that's the only one award which is available, publicly available as of today.
And talking about the arbitration framework in Malaysia, Malaysia adopted the UNCITRAL model law in 2005, as many of the CIS countries did as well. Are there any notable deviations, or is it a verbatim adoption of the model law enacted in Malaysia?
It's not a verbatim adoption. The most recent amendments were introduced in 2018, and I believe the local arbitration community is currently discussing the next wave of amendments to be introduced either in 2021 or 2022. It's not a verbatim adoption, but yeah, let's see how the act itself will be further developed. As of today, the act itself, because I mean it's based on UNCITRAL model law, it makes Malaysia a pro-arbitration jurisdiction, although Malaysia is still an emerging market. But if we look at the recent judgments of the Malaysian courts, we will definitely conclude that that Malaysia becomes more and more arbitration-friendly jurisdiction, especially when it comes to the interpretation of the public policy. In one of the matters 2 or 3 years ago, I believe the federal court mentioned that it's very important to interpret the term public policy very narrowly. And subsequent courts also rely on the judgment. So it's definitely a positive change. And let's see. I'm excited to see the next wave of changes next year or next year.
There seems to be another arbitration-related prominence of Kuala Lumpur, especially in the context of Vis Moot Court. So is it correct that the pre-moot in Kuala Lumpur is the biggest one worldwide?
It's hard to answer this question because we haven't made the inquiries. We haven't reached out to all existing pre-moots. All I can say that in 2018, we were really impressed because we registered 95 teams from all over the world. And actually 90 teams, they were physically present here at the AIAC for the pre-moot. I know that you also have quite a few successful pre-moots in Europe, but I don't think we should compete between the pre-moots. The main goal is just, provide a great training platform, not only to students, but to everyone, including young arbitration practitioners. And yeah, I mean, it's a very interesting initiative. We started developing it at the very end of 2016. And I remember how we were struggling at the very beginning. But the enormous support we received from everyone, from the Malaysian arbitration community, from the center itself, from the management of the center, from everyone else in the Asia Pacific, lawyers from Cambodia, from Vietnam, from Hong Kong, from Singapore. It's a team commitment, so to say, because it's not only the organization of the pre-moot itself, but it's also a commitment of arbitrators, arbitration practitioners, sponsors, supporting organizations. It's a great teamwork, and I was very happy to be one of the people who started this initiative here, and hopefully the center will continue developing this initiative in future as well. It gives us great visibility. It's very interesting for all of us to participate in it. It takes quite significant time to organize it, to be honest, but we're doing, we're doing something good. I believe it's a good initiative. It's a goodwill of our team, and yeah. Please, if you have time to participate in the pre-moot in 2021, it's going to be on a virtual platform. So Olga and Dmitry, if you have some extra time, please join us as arbitrators. As of today, I think we have more than 80 teams.
Well, that's impressive. And you were a successful mootie yourself. Do you have an advice to today's mootie of how to succeed and have fun at the moot?
I think the only one advice I can give, just believe in yourselves and work hard as you can. There is no secrets. It's just hard work and persistence. Especially nowadays, everyone has similar opportunities. Everyone has access to internet, to all databases, and a lot of different books on arbitration. Yeah, so everything depends on you.
Very good. It seems to be a universal advice also for other professionals or other areas as well.
And talking about the Vis Moot, the case discussed there is usually based on the United Nations Convention on the International Sale of Goods, CISG. To my knowledge, Malaysia has not ratified this convention yet. Do you know the reasons and the current developments in that respect?
You're right, Dmitry. Yes, so it's not ratified yet. I'm not sure about the reasons, but from what I understand, UNCITRAL is also planning to organize some events to promote CISG, to continue promoting CISG in the Asia Pacific and in Malaysia as well. We are organizing a conference for young practitioners a day before the pre-moot, and we are also planning to speak about the CISG again. The interest is growing. I'm myself a big fan of CISG. I love it. And yeah, let's see. I mean, it's just, again, one of the developments that will be considered in future by Malaysia, hopefully.
Maybe one more question on the AIAC. Your center is well known for its hearing facilities. So your center is able to offer all participating parties a hearing room for oral hearings.
Yes, absolutely. We have more than 20 hearing rooms. We have small breakout rooms, small hearing rooms, medium-sized hearing rooms, large hearing rooms, and extra large hearing rooms. So the center itself, I mean, our facilities, they were mentioned in the annual GAR survey in the last 3 years, I believe. And we receive a lot of compliments from users from different parts of the world. We have MOUs with ICSID, with the Permanent Court of Arbitration, with CAS. So we're always happy to host the hearings, even if it's not the AIAC administered hearings. And we do receive a lot of inquiries, not only from the local parties who are looking for the hearing venue in ad hoc matters, but also from other institutions. Especially nowadays when everything is virtual, we are also working with, partnering with different institutions to help each other, to connect the parties, to connect the arbitrators. And in this sense, this year was quite hectic for us.
So it means that it was no exception also compared to other centers. So you had to switch to the remote hearings mode as well.
Yes, and yeah, we also drafted the protocol, the virtual arbitration proceedings protocol and virtual mediation proceedings protocol. It's currently, both protocols, they're currently on the final stages of review, and hopefully we'll be able to release them to our users very soon.
And what's your experience with virtual hearings? Have all of the cases gone online?
Not all the cases. Some users and some arbitrators, they're still quite conservative about it. A lot of hearings, they have been postponed. Some of the hearings, they adopted so-called hybrid format. So some of them, they decided to, to conduct part of the hearing on a virtual platform and then postpone the in-person hearing until mid next year. So I think as everywhere else, depends. Everything is on a case-by-case basis. As long as the parties are comfortable with this arrangement, with the virtual arrangement, as long as the tribunal is comfortable and everyone has, equal opportunities, everyone can access the virtual platform, everyone has high-speed internet. It's doable. Yes, it was very popular this year.
Yeah, it seemed to be one of the main developments worldwide, actually, which have been forced by the pandemic. So maybe we can now come to the last part of our conversation and talk about dispute resolution in Asia in general, and think about possible future developments. So there, it is. One cannot argue that we haven't seen a huge development or shift even of arbitration in Asia or to Asia in recent years. So talking about arbitration proceedings involving Asian parties or in Asia in general, given your experience now, are there any specifics one should consider in such situations? Are there any cultural specifics you would advise to keep in mind?
It's also very hard to come up with commonalities, because especially in arbitration, everything is on a case-by-case basis. Sometimes it's an Asian registered company, but there is someone else who stands behind the company itself. But speaking of general features, Asia is a very happening place. And from what I notice is that a lot of arbitration practitioners, they are, more and more arbitration practitioners, they come to Asia to develop their careers, and the market itself is very sophisticated. As I mentioned, Asia is a very happening place, and it's a very interesting place to be as a young or younger arbitration practitioner. You can be involved in different developments, be they institutional developments or legislative developments, to participate in arbitrations under different sets of rules, whether it's the Hong Kong Arbitration Centre, AIAC, or SIC, or other emerging jurisdictions, VIAC in Vietnam, or Thailand's International Arbitration Centre. There is a lot of opportunities, and definitely the future is Asian. The future is Asian. Asia is a very diverse region, and speaking of, it's hard to find cultural differences, especially now when I spent almost 5 years here. But overall, I think there are many more similarities as opposed to differences.
And is it true to say that Asian people, Asian companies usually prefer consensual methods of dispute resolution? So basically rather mediation than arbitration?
Again, it's hard to say, especially when we speak about Malaysia. I know that the interest in mediation is growing, definitely. But I believe that most of the mediation matters, they're still ad hoc mediation matters. They are not registered by any of the institutions which can potentially administer these matters. Community mediation is developing very fast. The number of cases is growing. That's what I hear from members of the AIAC community here. Certainly there is an interest, and there is trust in consensual dispute resolution in Asia.
You have also mentioned previously that construction disputes are dominating arbitration markets in Asia in general. Do you see any developments or tendencies concerning other sectors? For example, like maybe what I also would be particularly interested in is our questions of technology maybe, or IP disputes. I mean, you've mentioned already that you see also energy disputes, but since at least in Western Europe, the perception is that Asia is leading when it comes to technological developments as well. Do you see disputes arising in that business sector already as well?
I see, yes. I see that there are many initiatives related to tech disputes. And the AIAC, as I mentioned, we created the tech committee. There will be an advisory board of lawyers and tech experts who will be developing this area of dispute resolution in future. Speaking of IP, definitely yes, this area is growing. The number of shareholders disputes is growing. Maritime, it's a bit of everything. I think we will need a few more years to see what the trend is. But as of today, it's a bit of everything, and with construction leading overall.
And considering the current developments, what do you think the future of arbitration in Asia will be like, let's say in 5 or 10 years' time?
Definitely the number of disputes will increase, especially the number of disputes seated in Asian jurisdictions and administered by arbitral institutions located here in this part of the world. And therefore the opportunities for foreign lawyers, I think, will be increasing as well. With the increasing investments from China, be it the Asia Pacific region or CIS region, the expertise of lawyers qualified in those jurisdictions, experienced in those jurisdictions, will be also in demand here in this part of the world. I'm not sure if it will happen within the next 5 or 6 years, but within the next 10 to 12 years, I think we will see more and more foreign lawyers, arbitration lawyers in this part of the world.
Very interesting. So I hope that I can only say that I hope that one day we will all get to see each other, and it would be a pleasure to meet each other in Asia. And it looks like really different business sectors. There is a huge, well, not trend, but even in some aspects, dominance of Asian markets, Asian companies. And it seems like a development which is, yeah, obvious. So I completely agree with you. That's probably in like 10 years time, we will see more and more disputes also being handled in Asia as well. Dmitry, are there any questions left from our side? It looks like we've handled a huge range of different questions.
I think, yeah, we've covered a lot already. Maybe one of the questions left is whether one of the most recent webinars offered by the AIAC covered investment arbitration. Does your center play any role in investment arbitration, administering cases, or mentioned in any investment agreements?
Yes, we haven't administered any investment arbitration matters yet. We did host an investment arbitration hearing a few years ago here in Kuala Lumpur at the AIAC. And yes, Dmitry, as you mentioned, the AIAC is mentioned in the ASEAN Comprehensive Investment Treaty as one of the possible arbitral institutions, depends on the party's choice. So the AIAC is one of the forums the parties may choose if there is a dispute arising out of the ASEAN Comprehensive Investment Treaty. As I mentioned, as of today, we didn't administer any investment arbitration matters.
And we've talked about the future of arbitration in Asia. What can we expect of the AIAC in 2021? Are there any concrete plans? You've mentioned the virtual hearings protocol. Any changes to the rules or anything else?
it's very hard to predict, to be honest. It's very hard to predict. Everything changes so quickly, not only at the AIAC, but in Asia. And I believe that the future is bright. The market, the ADR community here is very, is also growing. And everyone believes in ADR. Everyone believes in Malaysia as an arbitration-friendly seat, and hopefully the AIAC will continue developing in the next 10 years. Yeah, I mean, definitely, I think and I hope that the future is bright, but it's very hard to predict any certain changes.
Thank you.
Thank you, Tatiana.
Thank you, Tatiana. So thank you very much for this insightful conversation. It was, like, for me personally, very interested to get to know so many specifics about the center and arbitration in Malaysia and in Asia in general. So I think, picking up on your prediction of the bright future, I would like to thank you first of all. And since we are heading towards the end of not easy 2020, to wish you and the center and all of our listeners all the best for 2021. I very much hope that it will be a bright one for all of us. Also, I would like to thank our supporting organizations that supported most initiative from the very beginning: Caspian Arbitration Society, CIS Arbitration Forum, German-Russian Lawyers Association, as well as Russian Arbitration Association and Ukrainian Arbitration Association. I very much hope that we will all continue the conversation and be able to meet each other in person again in 2021.
Thank you very much, Tatiana. Happy New Year, everyone. And
thank you very much, Olga and Dmitry. Thank you. And
talk and see you soon. All right.
Thank you. Thank
you.
And happy New Year. Goodbye.